O.J. Simpson passed away, of course, recently after battling prostate cancer. And there's questions, though, about the large amount of debt that he held before his death. And that got us thinking, well, what happens if the same situation applies to you? Here to discuss what's involved in that matter and what the rest of us should know when it comes to estate planning is attorney Jeffrey Katz. Jeffrey, thanks for coming in today. Okay, so most of us are not going to be in O.J. Simpson's financial situation, right? Sure. He had a lot of debt. Obviously, the lawsuits, there was a lot of things involved there. But break it down real quick, because a lot of people were wondering when he died, you know, the Goldman family's been waiting on this money for decades now. Will they get any of it?
Probably not. So the Goldmans had a judgment which was worth approximately $33 million at the time of O.J.'s death. Unfortunately, O.J. also had significant debts outstanding to the Internal Revenue Service. Now, the IRS debt's going to take precedence over the Goldman's family debt. And what that means is because we think he's insolvent as of the date of death, that the federal priority statute basically super prioritizes the federal debt over the Goldman's debt.
So, and the bottom line here, really, when it comes to O.J. Simpson, then we'll put a cap on that and move on to other folks. But with O.J., it seems like because of the trusts that he had set up, really any bulk of his own money would have been in that trust, right? Which is then untouchable. Right. And then after that, it comes to basically the federal government gets their share first, and then anything left over would go to the Goldmans.
Yeah, so O.J. actually set up a revocable trust back in January. We expected he transferred most, if not all, of his assets to that trust prior to the time of his death. And so very little, if any, of the assets we think will actually pass through probate. And so what is going through probate, first dibs will go to the federal government. And if there's anything left, you know, then the Goldmans can come and make their claim.
So he knew that he had a lot of money, that he owed a lot of people, right? So he puts the money into the trust just a couple of months before he dies. Legal, doesn't sound maybe ethical, but legal, right?
Absolutely. And so we see trusts as really the operative way that folks are transferring the bulk of their assets, particularly where they have larger estates. And so for folks who don't have, you know, a whole lot of money, wills are still a great way to transfer their assets. But if you're looking to avoid that probate process, the public, you know, oversight of the assets and the distributions going through that public process, a revocable trust is going to far and away be a better option.
It just protects your money, right?
Absolutely.
So as far as what, you know, the bulk of our viewers are, I mean, maybe they'll carry debt on, so maybe we start with that then. If somebody passes, then what happens to that before the money comes down to the family, or how does that whole process work?
Absolutely. So in most instances, probate is going to be the state overseen process where a will is brought it forward. The courts determine who the beneficiaries are and who the creditors are. And then creditors typically have anywhere from 6 months to a year to file their claims before distributions can be made to the family members.
But the creditors will most likely get their money first before money's passed on to the family?
Yeah, creditors have first dibs on the funds. And so again, if there's funds that are left after the creditors are paid out, then those monies can be sent, distributed out to the named beneficiaries.
Okay, so it sounds like in that case, and this all comes down to dealing with your attorney or financial planner, however you work with it, if you have the ability to do so, that seems to be where the trust comes in then, if you do owe money at the time of your passing.
Absolutely. And so the other challenge we would have is that creditors can come in and claim that there was a fraudulent conveyance, that assets were transferred to the trust while that individual owed money to them. We see less of that. Again, that's going to be more of a private claim as opposed to an estate claim. But people can come in and bring those claims separately. Typically, they're not being brought in front of an orphans court, but maybe like a superior court or a circuit court, depending on the jurisdiction.
So for those who don't have a massive amount of money that will be passed on, or don't have a massive amount of debt, either way, what do you recommend as far as just, you know, for folks out there to, you get the will, or if you don't have the will, where the money goes? And for those, maybe a parent dies and now you have to deal with the probate process, what's the best advice?
So a couple things. One, payable on death designations on bank, brokerage, retirement accounts, as well as life insurance policies will bypass the probate process and allow those funds to go directly to your named beneficiary.
So have a beneficiary if you have any of those accounts.
Yeah, absolutely. And then having a will is a great way of also designating who gets the assets, when they get them, and how they get them. It's going to go through that administrative process of probate. And if you've got the assets and the resources to consider a trust is a great way of streamlining that process, ensuring that the funds go to your beneficiaries without avoiding, or while avoiding the cost and expense of probate, the time, as well as the public oversight.
Yeah, and listen, I've been through this process. Be prepared for a lot of talks with attorneys or other experts, a lot of paperwork and a lot of time, because this is not the kind of thing where if someone passes, you're settling this in a month or two. It's a very lengthy process.
Right, and so in Maryland and D.C., we have a statutory 6-month creditor claims period. In Virginia, it's a 12-month creditor claims period. And on average, most estates take between 12 and 18 months to administer.
So you might not get any of that money for a year or two after that.
Year and a half to 2 years is typical.
Jeffrey, thanks for joining us today. If you want to reach out to Jeffrey personally, you can do so. There is his information, but certainly do recommend that you get in touch with an attorney or an estate planner or a financial planner and try to get your affairs in order sooner rather than later. Thanks, Jeffrey. Good to talk to you this morning.